webinar started and we're recording, so I can call this meeting to order. It is 2:32 p.m. on March 8th, 2024, Friday. I will note the members present. So there's myself. I see Judge Hall. Oh, sorry, and obviously Laurel is with me. Mark is here. Jerry is here. Carol is here. Jeff Esmond is here. Dr. Fratarelli is here, and I see Lauren Kim is here. So for the folks who joined a little bit later, I don't know if you heard me introduce Sienna, who is in my upper corner. I don't know where she is in your screens, but she's also a Deputy Solicitor General with the Appellate Division here in my office. So one of my colleagues, she is going to be assigned to advise the task force. So she's like our Deputy Attorney General. So if you have legal questions or sunshine questions, you're free to email her, and we'll circulate her email. So when you email her, please also copy Tammy and Derek, who you've also been in contact with at the same time. So thank you, Sienna. Okay, so we do have more than a quorum of people here. As always, according to HRS 92-3.7a, if you're appearing virtually and you're in the room with someone who's 18 years or older, or someone under 18 who has business before us, you have to make that disclosure. I'll give people a chance to make that disclosure. If not, I will assume no one has to make any disclosure. So anyone need to say anything? All right, seems we're good. I will start off. I'm actually going to switch up the order of the items in the agenda. So I wanted to start with item B2. That's kind of the most pressing thing I wanted to make sure we talk about while we have everyone. And that is the schedule for us, like our internal deadlines and the deadlines that we have to do what the legislature told us to do. So hopefully everyone had a chance to read the memo that I circulated along with this meeting item. But basically, we all know that the legislature set a deadline of 40 days before the next legislative session to submit a final report with any proposed legislation. So that date, 40 days from the 2025 session, is going to be December 6th. Oh, I see Lauren he says he has to leave at 3:10. Okay, thanks for letting us know. So December 6th is when we have like a hard deadline to submit a final report to the legislature. But the report is going to be coming from I think it'll be coming from our department of the AG. So I talked to our legislative division, and they were the ones who reviewed our interim report too, and they did that submission on our behalf last session. So I asked them when they're going to need to see a final report so they can do their review and send it to the legislature. And they want it by the end of October at the very latest, which, really cuts down on the time that we have to finish our final report. So I wanted to talk with everyone to work backwards from those deadlines to set internal deadlines for ourselves, just so we make sure we're on track to give the legislative division a final draft from us by the end of October, so they have enough time to do their review by December. So generally, if you looked at my, this is just like a proposed schedule, but if you looked at it, generally what I'm thinking of is having all of the 3 PIGs that we already formed to kind of be done with their work and report back by a certain time. And then have probably another PIG form that's going to take all of those edits and make that into a final product. So the big questions are like, how much time do we think the pigs that we have now need to finish what we're doing. And how much time do we think a drafting pig needs to make a final product? So just in this proposed schedule, I gave that final pig, that drafting pig, about like 2.5 months. And then for the initial pigs to finish their proposed drafts, right now it's, and my proposed schedule, it's pretty short. It's about like 2.5 months from now. But that's because I anticipated maybe having the pigs like circulate a final draft to the other pigs and having the pigs review everyone else's drafts and then come back. So we could do that, but we could also maybe see if there's a way to kind of like build a review into the drafting so that we have more time. I don't know, I hope that makes sense to everyone, but for example, like what the legal parentage pig has been doing is like we've been making edits and then we're coming to you guys for feedback and then continuing to work on things. So hopefully by the time we have a final product, it has already been looked at by the task force as a whole, so it's not completely new to people. And hopefully that cuts down on time that people do need for review. So yeah, I guess I'll put the question to the other pigs, like how much, what do you guys think of, the proposed deadlines? Do you think you need more time to come up with a final draft for a draft of your sections for everyone to look at? So yeah, I'll turn that over and start the discussion. Do you have any?
Well, I'll start the discussion,
Sure.
even though I'm not really sure what I even want to say, but
Okay.
not because what I do want to say is thank you for giving deadlines, because I think deadlines, particularly when drafting legislation, are important. But having said all that, I'm sort of from the background where group drafting doesn't really work at a certain level, and at some point you have to kind of have maybe as few people as possible once the concepts are agreed on.
Mm-hmm.
But that's just been my experience. And something as complex as this, I think it's great that we've had the pigs and are going to get input. I'm just a little hesitant about each pig giving something and then having the one voice or the coherent outline or guidelines in there. So that's just my feedback, and other people may disagree, but I'm just a little hesitant on like drafting again and as a process. I'm not sure how well that'll work, but willing to try if that's necessary.
And I haven't done legislative drafting before, so if people have other suggestions, I would really like to hear it. But
yeah, Laurel, is there a particular alternative you had in mind?
Well, I think for our group, and I realize our group is number one, been very I think proactive, and people have been expressing things. I feel comfortable that we could give concepts, and in fact, because the Uniform Law Commission somewhat revised their position, right now I'm fairly comfortable with maybe a tweak or two that we could just use that, but we didn't agree to that. Okay, this is me speaking. I want to be very clear.
Yeah.
Right. So, yeah.
well, let me ask, do the pigs see, like, do they anticipate making big changes to the draft bill that's already being looked at right now? Or are you guys kind of like reviewing it to make sure it kind of comports with what you see as best policy? Oh, I see, sorry. We got some new attendees, so Thad and Dr. Andaya are here too. Thank you. Thad and Dr. Andaya. So what we're talking about right now is it's actually item B2. I skipped ahead. This is the proposed schedule for the task force. So trying to, set internal deadlines so we make sure that we are able to get a final draft out of this task force by the end of October. So yeah, sorry. So I guess my question was, yeah, like, do the pigs see needing to make big changes, or yeah, are you just kind of like reviewing right now?
Well, I know for the legal parentage pig, we're making not big changes, but there are a number of changes or specifications we're making. But I'm hoping that with each pig, any changes, they can maybe draft some proposed language, and then we can all take a look at it in one group meeting. So that way the drafting pig can basically just take that information and input it in a cohesive manner.
Okay, so do you think we need to do, what I kind of put in this schedule where like the pigs exchange edits and then look at each other's edits and then come back? Or do you think we can probably do that like in a larger group setting?
I think as long as we give everybody enough time to review everything before the meeting, we should be able to do it in a larger group meeting.
Yeah, I was wondering about that myself because I was thinking, I don't know that our comments would necessarily be made as pigs on other pigs proposals, right?
Okay.
They'd be more as individuals.
Right.
That would give us some time, because yeah, like I said, I made deadlines for a pig to finish everything before circulating it. But yeah, if we're able to kind of work as we go along and make sure we're bringing proposed language or, policy questions to the whole group, then we could, work up until the time that we have to give something to a drafting pig.
I do think these deadlines are very helpful, though. Speaking from personal experience, it's very helpful for me to know that I have a drop dead deadline that I need to really sit down and put pen to paper and go through everything line by line and
Okay.
get focused. So I think these deadlines are helpful, both within the pigs and within the larger group.
Mhm. Okay, and this kind of, I mean, this is gonna bleed into the other item I wrote down, which is talking about scheduling upcoming meetings, but I do think we should try to at least have like a meeting monthly on the calendar and have like a set date, and we'll see, we'll make sure that if people cannot come, that we note that, and we don't, so we can cancel a meeting if there's no quorum. But I think we should like at least have a kind of a standing appointment so that the pigs know that there'll be a date by which they can bring their edits back to the whole group. So we can talk about that more later, but just for this discussion too, I think that helps us kind of make sure we're meeting deadlines. So if we do what I think Judge Hall was kind of alluding to, like, and like what our pig is doing right now, like make changes and bring them to the group and have discussion on it. Do you think that like July is a good timeline for all the pigs to kind of have finished, have like their set of proposed language and proposed, I think we have to have language, and we should have like our section of a report, like what we would want to tell the legislature about why we're doing certain things.
Right.
Do you think July is a good time for that to be finished? Sounds like Judge Hall is saying yes.
Yeah, no, I agree. I think that's a reasonable time.
Okay. So I know we're hearing from Birth Heritage and Legal Parentage.
That's so hard.
Is there someone on, yeah, on assisted reproduction who can kind of weigh in on that? Does that seem, do these deadlines seem okay?
Oh, Dr.
Think-
Brown.
Yeah.
Oh, sorry, yeah, Carol, you're on it too. You're on
Yeah,
the-
yeah, I'm on both.
Right,
And
sorry about that.
yeah, like I said, I think this will help focus us.
And are you guys, I mean, I guess this goes back to my other question. Do you guys think that you're gonna have like really extensive edits on what's already in the bill, or are you just kind of making sure it tracks with what you want it to say?
I think most things are going to be tweaks. There may be, a place along the way where something comes up that requires a slightly more significant proposal, but I don't think we're going to be looking at earth-shattering changes.
Okay. Okay, so if July is like when we think when the pigs should kind of have their complete edits and reports done, are there like interim deadlines we can set between now and July? Again, I put in like, a deadline to circulate it with the other pigs, but if we don't want to do that, I mean, are there other like deadlines we think we need to have in between now and then?
I don't see anything wrong with the deadlines you have. I mean, it doesn't hurt to have the discussion early and we can tweak things as necessary.
Okay,
Because I think one of the discussions we probably have to have more sooner than later is the Uniform Laws Commission's new changes with regards to,
the donor identification.
yes, thank you.
Okay. Yeah, and obviously if there are things that come up in pigs like that need some kind of policy determination, we should bring that up sooner than later. So like, how we were talking about whether we should even expand the voluntary establishment of parentage or not. I know in like for the was it birth heritage or assisted reproduction? I think you guys were kind of having discussions about like genetic surrogacy versus non-genetic surrogacy. And it seems like everyone like kind of agreed about how that was gonna come up. But yeah, if there are questions like that, where you can't really like move forward until you get an answer from the group, then we should make sure that those get discussed earlier than later.
Lauren, I know for myself, even though I've drafted a lot of legislation,
Mhm.
these areas of law are so technical to me that I can read them, and maybe find if there's consistency or inconsistency or something, but really as a non-lawyer, being able to understand how that actually would work, I would be a little hesitant to weigh in on that. But I do think at some point, which would be July, I guess, looking at a first draft of how the pieces fit together are probably important.
Yeah.
Because I think, Carol brought up a couple things at our last meeting, last pig meeting about that, we have to make sure that it's, I would like it to be consistent. Maybe there would be times when it shouldn't be consistent, but I guess I don't know yet.
Yeah,
Until I maybe see the whole bambucha thing.
I'm really glad you brought that up. So when I went to the legislative division and I was like, when do you need to see our final draft? They told me to actually start, that we can give them things to review as soon as we have something on paper. So like for the legal parentage pig, we circulated those proposed edits. I think when you have something like that, you can already send them to the legislative division of our department
Right.
to review. And I think Judge Hall, you did that when you first put this bill together, right? So yeah, when you guys do have language and you want to make sure it's like internally consistent,
Right.
or you want to make sure it's not going to like mess up other
Right.
sections of the HRS, I think you could, send Tammy and Derek and Tiana those edits, and then they can give that to the legislative division to look at. And I think that's, because they're not part of the task force. I'm just trying to think this through. I think it's fine under sunshine. As long as, again, as you report back to everybody about what's happened, I think that should be okay. But yeah, so there are resources that can definitely help with that
Mhm.
aspect of drafting, and that should cut down on the time that, is gonna be needed for review later on also.
And Lauren, can I just add, I agree with Judge Hall. I think the timeline looks great. And then I appreciate that comment because, I know some of us are here not with that really in-depth kind of like technical legal expertise for this particular topic area. Something that had come up in RPIG, which I think could be helpful is, when we're kind of looking at this as a larger group, is to give examples of like cases that help us kind of especially for us who are lay people, to understand the implications of the law for someone who's trying to use what, or, how it apply. And in particular, of course, I'm here representing the needs of our sexual and gender minority communities. So I would go from that angle. But I think Mark, Jerry, and Judge Hall brought up good instances where how they'll, if we change the law to support those communities, how that might also affect other folks who are seeking to use these systems. So if we could include some sort of like case or examples, I think that'll help us elucidate what the impact of the law will be on people.
Yeah, definitely. Yeah, that's a good point.
Yeah, the reporting is really going to be important, I think. So that's why I think it's good we start, actually, that's why I was saying conceptually, if we can get our concepts down into something that would be included like in a report, I think that's going to be really, frankly, more important for the few legislators that actually think they're going to try to read, this thing and understand it. I think the report is going to be way more important.
Right, yeah, because the legislature, when they get the draft bill, they're gonna have to do their own review too.
Right.
With their own
And their staff
attorneys.
and-
Yeah, but if they understand why we're doing certain things, that
I
can
think
help
that is
guide
made a
them.
really good point. For each of these sections or parts, we're going to need to have some storytelling.
Right,
Okay.
Maybe that May 24th can be our concept deadline.
that's a good idea.
Okay.
Yeah, I like that, I think that kind of puts into words what I kind of want to make sure we get done. Like, at least know what we want to accomplish with the legislation, right? Okay, that's a really good idea. And then maybe, yeah, June can be well, maybe we can like have drafts out by June or something, and then finalize everything in July. Okay.
Yeah, I would push it because in case something comes up, it's better
Yeah.
to push it, and then we have to move it back a little bit.
Yeah, okay. Right, does anyone else have any comments they want to raise about this, about the deadlines or questions at all? Okay, and if, to the extent that the pigs are having difficulty like meeting, or if you think you're not gonna be able to meet a deadline, like let us know, and we can try to help out. Yeah, I think it's just better to identify any issues like sooner than later, so once you start having difficulties, just let us know. By us, I mean like me and Sienna and Derek and Tammy, and we can like try to see if we can help out. Okay. All right, it seems like we're good with this item. Brandon, are there any other people waiting in the Zoom waiting room?
Nope.
Okay, all right, so it seems like we have no public testimony on this, so I'll move on to B3, which again it kind of segues from our previous conversation. So this is the scheduling of future task force meetings. Like I said, I think we should set up kind of like a standing meeting every month, at least like every 4 weeks or so. And it seems like Friday afternoons are probably okay. Again, we don't expect everybody to attend, but I think instead of like doing what we're usually doing and trying to find like, trying to coordinate everyone's schedules, we'll just like set dates, and then if you cannot come, you can let us know, and then that way we'll know whether we'll have a quorum or not, and then we can know whether to reschedule. But then everyone at least has something on their calendars. So I think that'll be good, unless anyone has comments or questions or any other suggestions about that. I think that's what I'd like to do. Oh, and then, yeah, like I said, because to identify issues earlier, if you're in your pig and you think, oh, we really want to have a meeting sooner than later to sort out some policy issue or to raise something that we need to figure out first, then definitely reach out and we can schedule a meeting sooner if that works. Okay. Oh, and then did everyone, so it seems like the system we had where there was like a calendar invite with your Zoom link and reminders worked out. Okay. I think we'll try to do that. I think we'll try to do that again. Oh, Mihoko's
So,
Yeah, I tried to invite her. She's in the attendees, but
Oh,
I guess it got rejected, so sending it again.
okay. Oh, there she is.
oh, there she is, yeah. Oh, welcome.
Hey guys, sorry. I was listening for a little while as a not as a panelist.
Okay.
Hi, Mihoko.
Thanks, Mihoko.
Everyone, sorry about that.
Okay. Mihoko, I can follow up with you about stuff we talked about earlier.
Okay, sounds good. Thank you.
So, okay, so yeah, we'll try to do meetings. I'll try to do the meeting every month thing, and we'll use that calendar invite system. So be on the lookout for that. Again, Brandon, no one else from the public?
Nope.
Okay, so that's well, I'll close out that item.
Well, real fast, Lauren, did you
Sorry,
have a time frame in mind that you want us to start marking our calendars, like the second, and what is this?
Oh,
the
like what part of the month?
Friday or anything like that?
Yeah, I think Friday afternoons seem to be okay.
Or were you looking like the second Friday of the month or anything like that? Did you have in mind?
Probably maybe like the second or third Friday of the month. We're early in the month now, so if we did the second Friday, that's about a month from now. Okay, sorry, I should have asked if there's any other questions. Anyone else? Oh, Jeff asked for maybe a little bit earlier.
Oh, yeah, he's gotta get his. kid.
Yeah, okay. Yeah, we can try for earlier.
Yeah,
Maybe
that would
like-
help too.
Maybe like
Yeah,
1 or
maybe.
1:30-ish after
Yeah,
lunch.
mine's actually been texting me during the meeting.
Okay.
Uh-oh. So
Okay.
1:30.
Yeah, let's do like 1 or 1:30 then.
Yeah. fine. So the second. Okay. This-
Okay. Yeah, maybe 1:30. People can come back from lunch. All right, anything else about scheduling? Okay, and since there was no public testimony, we can move on. So we'll move on to, I think this is B1. So these are the actual updates from the different pigs. So from the legal parentage pig, hopefully you guys got a chance to look at our report, which builds off the discussion we had, I guess it was back in January already, where we had asked you folks whether, we're in favor of expanding the scope of people who can use the voluntary establishment of parentage procedure. Again, that's like what you can do at the like at the hospital if you're not married to each other. And that's just kind of like, that's just kind of like an automatic establishment of parentage once you fill out the forms and if you're qualified to do so. And it seemed like people were generally in favor of expanding that and also in having like another procedure for uncontested parentage adjudications. So what we did was to put in some proposed language that we think accomplishes those goals. So let me see if I can summarize it without reading from the whole report. Yeah, so we didn't really make extensive edits, like I think Judge Hall mentioned, but the main changes were just to allow what we defined as professed parents to utilize the VEP process, or to use a expedited uncontested parentage process. But we would only define those professed parents as people who are not genetically related to the child, but only in situations where the actual potential genetic parent is not known. So that wouldn't be a ton of people, as you can imagine. But what it does is kind of make this gender neutral category, whereas before, like pretty much any man who's unmarried to the birthing mother could still use the VEP process, but women were not allowed to do that unless they were also married. So it does, you know, again, it's not going to apply to a ton of people, but it does like create this gender neutral category. And we also, you know, heard that we don't want to, heard from the other members that we don't want to, you know, make it so that the process like erases the identity of a known genetic parent. So that's why we limited the professed parent definition to only those people who are professing parentage when like the actual genetic parent is not known. Otherwise, if there is like a potentially known genetic parent, then you know, again, if the professed parent isn't married to the birthing mother, then the only way for them to establish parentage would, I think, be to, you know, be able to, after birth, establish themselves as a presumed parent by, like, I think it's like by marrying the birth mother or by holding themselves out to be the parent of the child for like a number of years or something. And then having themselves adjudicated as the parent, or they would have to go through adoption. So
Can I translate to make sure I'm understanding, translate that into a real life example that I think will help some other people who said
Yeah.
that those help. So what we're basically saying there is, say mom had a boyfriend, got pregnant with boyfriend, and since broke up and now has a new boyfriend. So when she goes to the hospital to give birth with new boyfriend, she can't cut off old boyfriend's potential parental relationship with the baby by deciding to sign up new boyfriend because that's the one she likes right now.
yeah,
Essentially, I mean, in terms of scenarios that Judge Hall I know has seen before, it's very common for them to be sick and tired of the one that they don't want to be with anymore. So hey, I got a new one. I'm going to substitute him in. But we're saying you can't do that if you know who your genetic parent is. You can't cut off their parental rights by putting a new parent on the thing. Is that would that be a good summary?
I think that's a good summary. Yeah, and definitely, at least not through a voluntary process like
Right.
this expedited process, or even the
Right.
expedited process. They would have to like go to court, have a hearing,
Right.
serve
'Cause
notice on the old boyfriend.
We need somebody like Judge Hall to have eyes on it in that circumstance to make sure that doesn't happen.
Right.
Yeah,
It would only,
okay.
it would, like I said, it wouldn't be a lot of scenarios, but it would be like if for some reason, like the mother just does not know like
Yes.
which individual
Yeah,
is the parent,
that
but what she does have is someone either
Yeah.
male or female or non-binary, whoever, who does want to be the parent and who is willing to step up. In that like pretty narrow situation, they'd be allowed to do that.
Right. Same scenario, just the first, which happens actually fairly frequently because that's a lot of our adoptions arise out of anonymous encounters. So she had an anonymous encounter, but since has developed a meaningful, significant relationship, and that person is willing to step up. She can put that person down because she doesn't know.
Yeah.
Right.
Can I ask, so Oh, Jerry's gone, right? Mark, does that work for the child support enforcement? Because I know that was an issue before, trying to figure out.
Yeah, I mean, I think we can make it work. You know, and speaking with Jerry after we came up with this language, I mean, I do have some concerns
Mhm.
about utilizing the professed parent, and I think the intent, the reason we came up with the professed parent is we wanted to be able to allow a vehicle, the VEP, to be used for a larger population than just a possible genetic parent or an assisted reproduction situation.
Okay.
But the way that we came up with it with this, so for example, I think the idea is we wanted to allow individuals who are in a relationship, like unwed couples, to have an opportunity to sign the VEP, but we wanted to exclude like genetic relations. Like we didn't want to allow like a grandparent or a sister or somebody to sign on. But I think what the issue is now is we could have a situation where you could have under what we've come up with, you could have a friend of
Right,
the birth mother sign on, and there
right.
would be no judge reviewing it, and that
Right.
could lead to potential abuses. So I think, you know, if we're going to move forward with the professed parent, we have to look at trying to tighten that language up.
We were kind of thinking like how to define, like, you know, if we want to keep it to like romantic partners, like how would you define that?
Lord.
But even that,
some-
even that's challenging though, right? Because the scenario I gave, if it turns out she's a serial dater and
Yeah.
the one she happens to be with at the time that she gives birth signs off, does he fully appreciate that he's signing on to an 18-year commitment right
Right.
then, and possibly longer? Or is he, I'm in love right now, and so of course I'll be your baby's parent, and then what happens if they break up 6 months later? So that'll be, I could see that being a challenge for you guys, Mark.
Yeah, so definitely we need to, like, to implement this, we need really clear instructions to the people who sign the VEP form.
Like informed
Yeah.
consent, you mean, that kind of thing?
Yeah.
Because I'm really concerned about
It's a
I
very
agree
serious
with
commitment.
the judge and Carol. I'm a little like, okay,
Which I think is required now, right? Like
well,
any guy can, any
Yeah,
man,
that's true.
I think, can sign the VEP form right
Right.
now.
Yep. Yeah, it's not new in that sense.
Mhm.
yeah. Right, okay.
May I say something?
Yeah, Jerry, please.
Oops,
Oh, no, Jerry.
Jerry.
Program provide brochures. Oh, are you able to, I'm sorry.
Can't see
We
you
can't see
anymore.
you, but we can hear you.
Yeah, don't know what happened. Just one. The current VEP program provides brochures
Right.
to the mother and the alleged father. It also provides information on the form as to the rights and responsibilities.
How many languages are those in, Jerry?
Pardon?
How many languages are those in?
Right now, it's in English, but we are eventually looking to have it in other languages. But right now, it is in English. And I think the parties rely on friends who are versed in English and the other language to make that translation. But my understanding is that the time frame in which the individual, the mother, birthing mother, is at the medical center is limited. It used to be a few days longer. So the time frame to even do this is a narrow time frame. And we've tried to condense it in terms of the information provided so that the hospital, the staff themselves are given a short instruction sheet. to address possible questions that individuals may have. Mark and I discussed that although we don't use the term genetic parent, it is implied that it is a genetic parent, that it is the biological father who is signing. Again, though, it can be a situation where mother may think the person who is signing is a biological father. That is, she has probably made that representation, and that is why the individual is signing. We now have a situation where we're creating this new definition. It is outside the Uniform Parentage Act. It's called professed parent. I know Mark indicated that he has concerns, and I do share his concerns. That it can be used and abused by individuals wanting to have access, legal access to the child, without much effort on their part. And that is, I think, the biggest concern, that it would be subject to abuse, especially when the focus is now not on it being a biological parent, but another party who has an interest in being the parent. Mark, did you have anything else?
Yeah, my only concern is absent a marriage, you know, a legal contract. I'm just nervous about people that are non-genetic being put wherever. But you know, I've said this before, so I'll just stop there. But
Right. So I guess that, I mean, that concern would still, I think it would still exist under the current laws, right? Because
yeah, I know,
A
I
male,
don't like
yeah.
those either.
so it's like we might have, if it's kind of like deciding, we'd have to decide, but not just between expanding and keeping it where it is, but like expanding or actually kind of restricting
Right.
the folks who
Yeah.
could sign it right now. Yeah, and that's a
Yeah,
good
no,
question. I can see it both ways
Yeah.
too. But yeah, I think that the other thing to keep in mind is like if we keep, you know, just if we have the current situation as the baseline, it does, you know, we were tasked with coming up with like gender neutral language,
Right,
and
right.
that's
No,
kind
no,
of like
and
the
I
most,
don't have a problem.
Yeah.
The gender is not the issue for
Yeah,
me. It's
that's kind of
it's
like the most
lacking of a legal
prominent-
contract. That's the
Right.
problem.
yeah, that's kind of like the most prominent example that we saw, that like
Yeah.
where men and women were not
Yeah.
treated equally
No, they're
in
not.
the current law.
They're absolutely not.
I think we have to go into it assuming there will be buyer's remorse on both sides. There will be people who take on there will be people who take on a legal commitment, and then later on when the relationship breaks up are saying, "What do you mean I'm stuck with this commitment?" And then there will be people who give somebody parental rights over their child who is not a genetic parent and are going to later on regret. I get those kind of calls all the time. I had somebody just call me recently because a relationship broke up, and genetic mother wanted new partner to be the partner of the parent of her child. And I had, in that case, it was presumed parentage. There was a marriage, but the same issue still arises where somebody says it was a same sex couple. So she's like, this is not even a genetic parent, but now she's the parent of my child forever. And I said, yeah, under the law,
Yeah.
you know, because you were married when you gave birth. So it's going to happen either way, but there will be buyer's remorse.
So another option B that we considered is an uncontested paternity process that does require a judge to review the documents, but doesn't require a court hearing.
I'd be fine with that.
So we did make a slight modification to the statute to allow for non-hearing proceedings. Because currently the way the statute's written, everything has to be set for a hearing.
Yeah, but so to be clear, under the uncontested proceeding too, you still need I mean, it would still only apply if you don't know the other genetic parent of the child.
Well, it can apply if you don't know the other genetic parent, or if it is the presumed genetic parent. And
Presumed
they
genetic
just, for whatever reason, didn't do the VEP.
Yeah,
Or if, let's say there's another option is if there's a legal parent, let's say she's married, but everyone agrees husband's not the dad, that this is another process where they don't have to come to court to establish who dad is.
mhm.
If we eliminated the use of professed parent, we would still be expanding out the use of the VEP by allowing situations where there's assisted reproduction or in sperm donor cases. So it would be open to a small population of same-sex females, right? So there
Yeah,
would be
as
some
long as
expansion of it still,
Right, as long as they're using assisted reproduction.
right?
And it's not just like one of them is naturally pregnant, but just from someone they don't want to be the parent anymore. Yeah. Oh, and then another clarification on the process that Judge Hall mentioned. So in our proposed edits, I think it was only like a pretty small edit to expand or to like create this uncontested parentage proceeding. Like all we said is that a judge can in their discretion waive hearings when parentage is uncontested or something like that. But we know that there were, I think last time we talked about like concerns about, how that's gonna work in principle. So we are working on drafting like instructions and maybe forms for the courts to use, but the courts it's in their discretion, so they can decide to adopt those instructions and forms, but we wanted to give that as an example that they can use and to also like show how the process would work.
So just to be clear, we're going to create sample instructions and forms just so everybody can see and get an idea of what the process would look like. But the bottom line is because it gives a discretion to the judiciary on how the process will work, and each circuit does things differently. It may not look exactly like how the sample will be if it actually gets implemented.
So like generally we would say like, here are the forms, like if you want to do uncontested parentage, here are all the forms you're gonna need. Make sure that the other parent has notice and signs off and things like that.
To give people an example of why that would be helpful, for example, right now, when I have a surrogacy where somebody is either a paid surrogate or a family member, I have to bring the surrogate and her husband to court. But if somebody gives up their own genetic biological child, they sign a form and they don't have to show up. So it's kind of funny. Somebody can relinquish their actual biological genetic child and never show up in court, but I have to bring the paid surrogate who signed documents ahead of time and documents after the fact and everything.
That should be
So that will be helpful to not to have to drag them into court as well.
Yeah. Okay. So I don't really know how to close out this discussion, but it sounds like we, as a group, we should think more about the professed parentage or the professed parent language. And again, whether we want to use that or whether we want to, like allow professed parents to use the VEP process, whether we want to just channel them through the court instead, or whether we just want to, or I guess another option is to keep things similar to how they are, but it sounds like we do have to talk about that more.
So Lauren, could we do this, the next meeting? So now everybody kind of has an idea of what we were talking about in writing. We come back together, everyone can give their input. Maybe we can get a general idea of where the majority lies, whether we keep it in or not. And then also by the next meeting, we may not have all the forms ready to go, but at least the instructions should be ready to go for an uncontested case so everyone can see what it'll look like.
Yeah, that's a good idea. Okay, yeah, so for the next meeting, yeah, I guess come prepared to offer, your thoughts on whether we want to keep, or, yeah, I guess your thoughts on the proposed edits that we circulated, specifically the professed parent provisions. Okay. Anyone else from my pig want to share anything else? Okay.
Sorry, Lauren, it's
go ahead.
Betty's. So just in regard to that, that the instructions and everything, it's just something I'm gonna put it out there for the group to consider for future discussion, but we don't have to discuss it now, I'm more than happy, since I work with community partners, to look at that and see how that could be, the language could be helpful, or to create like a separate translated document that helps, that is more public facing. So we have a technical document and then a public facing one. So I think, the idea of dissemination to community members who it might most affect would be something to consider in the future as well. I don't know if that's usually included in reports, but I think it'd be really meaningful.
Yeah, that'd be great. I think that'd be really helpful. Okay, well, so that was the update from our pig. I guess I'll ask the Birth Heritage pig for their updates. I know you guys circulated notes too.
Right. Okay, ours, we considered the language, I believe, everyone had taken a look at it, that was recently submitted by the Uniform Law Commission. We had a pretty good discussion, I thought, and definitely it's from some of us, it's an improvement from what was in the prior draft, that had been presented by the commission and also at the legislature. There are concerns, though, that there are some implementation issues probably, and I know Carol brought up a good point, which is the way this is worded, it would only apply to donors and persons receiving donations in Hawaii, and so that's a very small population currently. So that is somewhat of a loophole. And I know that there's that same issue with adoption records, which is if a person was born here but adopted out of state, they cannot actually get their family court record because they were, the record in some other state. So there is a loophole with that.
Laurel, can I clarify that real quick?
Yeah.
Okay. Yeah, no, it was just that it only applied to basically sperm banks or facilities licensed in the state of Hawaii. And so the largest sperm banks used nationally are California Cryobank and Fairfax Cryo. I mean, people know what side of this I come out on, so I don't actually have a problem with that. It actually made it more palatable to me. But in terms of people who have the goal of requiring, very open disclosure, it's not going to achieve that much. I mean, Dr. Frederelli can probably give us a sense of how often the donor material he uses comes from inside the state, and how often it comes from outside the state.
The donated material or donor sperm we see inside the state is really just all known donations, and it's probably 20%, 1 out of 5 couples, 1 out of 5 patients will use a known donor, maybe a little less. Majority of patients use anonymous donors from out of state.
Right.
I would say, I think, Laura, we did have consensus on, I think, the concept that where people have information, it is desirable to preserve that information in the records in much in the same way adoption information is preserved. So for instance, my sons were born through an anonymous donor, but I have 75 pages of information I got from the bank. I would have, I could in theory provide that information. It could be, but I mean, that's going to be a lot of information for them to store at the Department of Health. And I don't know if they really want to take that on. It's already in the possession of their biological mother and the person who's raising them. So,
well, and the bank is required to keep it for 30 years. Yeah.
Well.
So,
yeah.
So we have access to it.
Well.
Yeah.
Right. I think what, the point though, I think of what we did with adoption records, and this is, you know, a person should have agency at age 18. And they shouldn't have to go to their parent after that to get information. Because, you know, sometimes you all that have children, I haven't done that, but know that sometimes, you know, especially during that time of, you get into age 18, 19 and want to separate from your families, maybe isn't the best time to be approaching your parents for that kind of information. So I think that's part of the issue with advocating for it being kept somewhere where when you're 18, you can go get it and you don't have to go to your parents for it. I think the other point that I know that we made that we talked about was, you know, trying to be consistent between adoption and children that are from ART or surrogacy as well. And I know Cheryl made a good point that really it would be helpful, and this goes along with informed consent, having some kind of counseling or parenting classes. I don't know how we would fit that in or mandate it through a law. I don't think we probably can. But if there could be something in the report, I think it's really an important recommendation that people think about 18 years down the road. That it's, you know, it's wonderful when there's a little baby staring at you, but it's different when you have an 18-year-old staring at you. So anyway, I think we've had a really productive few meetings, and Carol was gonna, I think, look around for some other potential information from other states, I think, laws. And I don't know if Jeff wanted to add anything. No, or Cheryl, since I sort of spoke for you. Okay, but that's all I have.
All right, thanks for giving us that update. So I don't know if I had, does anyone else have a question? Oh.
I actually had a question. I just want to confirm what Dr. Federelli said. The banks have to keep the information for 30 years, you said?
It's either 30 or 20. I'll have to look that up. It's either 30, yeah, but it's required by the FDA that it's either 20 or 30 years that we have to keep that information.
Oh, that's good to
And
know.
it's electronic now, so it's basically kept forever.
I'm sorry, that's an FDA requirement, so
Yes.
nationwide, okay.
Yeah.
I mean, not that it's necessarily relevant to this discussion all that much, but for instance, my son just turned 18. He now has a right to write the bank and ask for information. There's no requirement.
Right.
Oh, yay. I'm sorry. I'm just going to share it with you guys because you were on the phone. I just got a text that my son got his first college admissions.
Yay.
Sorry.
Congratulations.
It's the very first one out of 12. So, oh, thank God. He will go to college.
Oh my gosh, that's huge.
Yeah, that's a big relief.
Congrats.
Congratulations,
Sorry.
Carol.
That's huge. No, that's big.
It just popped up, so you guys get to hear it first.
Oh.
Yay.
So,
Yay.
Carol, you said that he can write to the bank to get the
Yes.
information. Is that
Yeah.
also from the FDA that they can do that?
Yeah.
I don't know. I don't know if there's an FDA requirement. It's a standard policy in most cryobanks that you can at least make the request. I mean, not unlike what we used to have for adoption in Hawaii, right? You can make the request. They don't have the ability to force the donor to respond. My son, honestly, he has no interest right now in making the request, so he's not following up on it, at least for now. But it was another thing we talked about. I think, Laurel, and you mentioned in the report. You know, we belong to a Facebook group with like 40 siblings on it, so he has access to a lot of biological relatives with some relevant health information and stuff already too.
Yeah. Carol, would you know where we could find? I'm kind of surprised too. Do you know where that is, or would Dr. Federelli? Do you know? I mean,
I'm sure we could find out.
Regulation buried in 10,000 pages of.
Yes, it's the Code of Federal Regulations and the FDA requirements. I can look it up.
That would be helpful. Thank
Yeah.
you, because I would like to see it. I'm very interested in that, actually. Okay, thank you.
So we have not come to consensus in our PIG. I would say we've had a lot of really good discussions, and ultimately, I have a feeling consensus on how we ultimately approach it is going to come probably from the larger group, not exclusively from our pig.
Right.
I remain very sensitive to not imposing anything on infertile couples or same-sex couples that isn't imposed on other people. As much as I love the idea of parenting, like I would love to see our medical system develop something like the French system where you get 5 days in the maternité where you're trained to take care of a baby. I'd
Yeah.
love all that. But once again, imposing additional hurdles on same-sex couples and additional hurdles on infertile couples that other couples don't have to do, I start to kind of wrestle with conceptually. So there will be much to talk about.
Yeah, and then when you talk about, lack of consensus within the pigs, I think those things can also like be worked into final reports too. So the legislature knows we came up with something, but like here's
Here's what the debate was. There was it's valuable information, and honestly, it's valuable to have different perspectives. It would not be, were there not good discussion on it, it would not be as valuable as it is having people with very different worldviews, different backgrounds, different personal experiences.
Yeah, and they might choose to run with something that's not the consensus of the overall group. So
yeah.
Okay. Yeah, any other questions for the birth heritage pig?
Lauren,
Sure, yeah, Jerry.
Jerry, yeah, I was just thinking back, and the question had been whether or not the VEP form is in multiple other languages other than English. And right now it isn't, it's in English. However, we are, along with the Department of Health, Child Support Enforcement Agency, we're working together to have an electronic VEP program, hopefully by the end of the summer. And that will allow the persons utilizing this electronic program to access other languages, multiple languages that is available on the internet. So to that extent, that individual who is reviewing the documents will have it translated in their primary language.
Good.
Okay. Thanks, Jerry.
Yeah, great.
Welcome.
Anything else before we move on to the next pig? Okay. All right, I'll ask the assisted reproduction and surrogacy pig if they have any updates to share.
I'm hoping we didn't meet, because if we did, I wasn't there.
Oops.
Yeah, we need to schedule.
Okay.
Yeah. I was thinking the same thing, Carol.
Thank you for confessing. Don't leave me
I was like,
dangling.
oh my God, I wasn't sure if
Awesome.
I missed the meeting. I've been busy also, so yes. Okay, we need to schedule a meeting. Let's do that.
Yes, well, we have deadlines now. You'll find out. We have a whole.
Yes, I see them. I see them in that.
And you guys can like, you don't have to communicate just in a meeting. You can totally email, call, do whatever within your pig. But yeah, I mean, I just wanted to I don't know if you have a sense yet, but like, do you see making, like, do you when you look at the draft bill, like, do you see any big glaring problems there from your perspective, or you think it'll be?
I don't think it's big glaring problems. Do you mean, I think it's going to be tweaking.
No.
Okay.
I think we were looking at, I mean, even in the first review, I think we had talked about tweaks about, lack of clarity of certain terms, or, should this be worded that way? Why is it worded this way? It was more small tweaks throughout.
Okay.
Yeah.
I have a little bit of an advantage because Judge Hall was kind enough to let me review the statute last year. So I've been through it once before.
Great, awesome.
And we talked about the utility of keeping the genetic surrogacy in
Oh, okay.
intact.
Right. Yeah.
Yeah, because I remember
Yeah,
last.
that was our biggest issue. That was our biggest issue, is whether we even want to provide for that.
Yeah, so you think there's, I mean, I'm just like trying to get an idea. Like, do you think you might keep it in as like a potential option for the legislature, or would you like, just for them to decide, or would you recommend against it, or?
I think our sense was it's one of the areas that's most likely to get pushback, and it's also one of the areas that's most likely to produce a lot of legal complications. Because, for instance, when I advise clients, I tell them if you're using a genetic surrogate, you have to be prepared to share custody for the rest of the child's life if the surrogate changes their mind. Because I don't see somebody forcing just a genetic surrogate to relinquish your parental rights. So it's just much more fraught than non-genetic.
Right. I guess that
And it's very rarely done.
yeah.
I've done none in my 25 years. So.
Right. Yeah, I was gonna say, so even if we like have a section in the HRS that technically allows for it or that regulates it, doesn't mean that practitioners are actually going to utilize that process.
Well, and our concern was actually a little bit more, we don't want to incentivize people or suggest it. And that would be my other concern is if people say, hey, I didn't really think about that as an option, are we gonna actually encourage it by providing structure? But I'm interested in Judge Hall's take on it because she's put a lot of thought into this, I know.
So
Well,
a couple things. One, can you possibly explain the genetic surrogate so everybody's on the right page?
Right. Well, and it can be pretty comical because, okay, so a traditional surrogate or a genetic surrogate, of course, is where you are using the surrogate's own ova. Right. And the reason it gets comical is that's when we also have people suggest that perhaps they could also bypass the fertility clinic. And we're thinking about doing a traditional genetic surrogacy. And I have to tell them there's no such thing as a traditional genetic surrogacy. And if there's not a clinic involved, that's not going to be a surrogacy.
Adoption, yeah.
This is not, you're not Abraham and she's not Hagar or whatever the name was back in the day, but this is not how we do things.
Biblical genetic surrogacy.
Exactly. Biblical genetic. Alabama would probably put that in their statute. But anyway, yeah, so the reason it's much more fraught for us, and obviously Judge Hall knows way more about this than I do, is because, for instance, with adoption, we don't allow people to relinquish their parental rights in their child for an adoption. We don't allow women, in particular who are giving birth, to relinquish their parental rights in the child until after the child is born, because we feel like she has to really know what it feels like when the child is there and see the child and touch the child and really make the decision once she's already given birth to the child. And so saying that a surrogate is somehow more capable of making that decision before birth with her own genetic child when we don't allow other people to do it is fraught. And we don't tend to involuntarily remove the parental rights of genetic parents unless they're proven not to be qualified to be a parent, if they're not proven to be a bad parent. So if a surrogate changes her mind, that's probably not enough to make her a bad parent. Yeah. So she's probably going to end up with parental rights. And especially if it's a context of people who aren't related. I mean, you could argue, I guess it would even do more damage in the context of a family, but also in the context of strangers, they're going to be co-parenting a child for the rest of, that child's majority and a minority and possibly beyond if they, as we know, we've got some laws that talk about kids going into college and stuff. So it's a long commitment to be making to somebody who may not be required to give up their parental rights. So I've had people approach me about it over the years. The only time I've ever considered it and said, if you want to go for it, I'll help you, but there's going to be caveats out the wazoo was a brother and sister, and the sister was in a same-sex relationship. The brother was in a same-sex relationship. The sister already had 4 kids of her own, that kind of a thing. But any other circumstance, I've told them I can't, because I can't give you any assurances at all that this is going to be considered a surrogacy at the end if she changes her mind. You're going to be co-parenting, most likely. So I don't know if the risk of putting it in there and suggesting to people that it's an option is going to cause more trouble for us than it will solve, since we don't get that many requests for it now. So just something for the group to think about.
Understood.
I think Dr. Fraterelli was trying to say something, but
he's used
No,
to
I was going to explain just what Carol just did, but I think that the reality is it's more of a legal issue than anything for us, for reproduction, for medically. Most of us are just going to say no, we don't do that. It's not what we would recommend, and we would suggest something else and explain to them why. But ultimately, legally, it's going to be the biggest issue later on. Whether or not the baby is going to be given up or not, and that's the biggest issue for our couple. And obviously, we're trying to help the couple in front of us or the patient in front of us with a baby. And that may not happen if you're doing a genetic surrogacy.
Yeah, that's really interesting.
I found it, I mean, on the first draft, not the ones where we're now, very confusing to even read the thing, to be perfectly honest with you. It was very convoluted, and I know somebody that Judge Hall and others worked really hard, but I remember reading that and just going, what are we doing? So just from a drafting perspective, besides what I'm just hearing legally and otherwise, I wouldn't put that out there. I think it's gonna complicate, especially after what just happened in Alabama. Oh my God. So,
I agree with Laurel. I don't think we should include it. I think it should be removed.
Okay, so is this the bad time to mention that the Alabama thing makes me wonder if there's room in the statute to affirm IVF?
well, we'll see what happens, in November. That's all I can say.
I do think that, you know, there are discussions about what, if anything, you know, Hawaii wants to do to reaffirm IVF, you know, just in reaction to what's happened. So I wouldn't dismiss that out of hand, Carol, because, you know, I think there are discussions happening right now about it.
Thank you.
I did see the head of Resolve speaking out and saying they were very unhappy. But then some of the stuff she was saying was like, well, we don't want any regulation at all. So then I was getting kind of nervous. So I'm not really sure where that organization is. I mean, they've been around a long time, but it could have been a moment of passion. So maybe we could check in with them at some later
It was
point.
probably inartfully expressed, is my guess, because they usually, every year they have a day that Dr. Frederelli has participated in where we testify on the Hill virtually.
Yeah,
And it's always about very specific, very detailed legislation. That's all kinds of
Okay.
regulation. So
okay.
they work on drafting good legislation for the most part.
Okay.
They don't want the Wild West.
Yeah, okay, that's what I was hoping.
No worries.
Yeah, no, I think if there are, if you see, you know, you shouldn't just be like limited to like what's currently in the draft, obviously, like if you see room for additional like language, I don't know, something more protective of IVF, for example. I just off the top of my head, I don't know what that might be, and if that would be, if this, you know, this bill would be the best place for it, but like, I don't know. And I'm just saying, like, you're not bound by what's currently in the draft anyway.
Thank you.
Anyone else have questions for the assisted reproduction pig? No? Okay. So that was all of the updates from the pigs. Brandon, I assume no one from the public has joined and wants to testify?
Correct.
Okay. All right. Well, thank you so much, everyone. I think this was really, really productive and helpful. I will see if, well, I'll take care of scheduling upcoming meetings, and I'll try to revise some of these deadlines and circulate those too. To the extent I'm gonna check to make sure I can do that. I'm pretty sure a scheduling thing I can just circulate. So, but I'll double check on that. Anyway, yeah, any other questions before we adjourn? No? All right, thank you so much, everyone. It is 3:45 p.m. and I will adjourn the meeting. Thanks and have a good weekend, everyone.
Aloha, happy aloha.
Thank you.
Thank you.
Bye.
Thanks, everyone.